Mr. Chief Justice, and may it please the Court, I, Leah Phillips, and my co-counsel Elijah Johnson are representing the petitioners for this case. Because we believe that the Second Amendment protects the right of citizens to keep and bear arms, we ask the Court to rule that the state's denial of petitioners' applications for concealed carry licenses for self-defense violates the Second Amendment. After a brief overview of the facts, we will present some supporting evidence for our two main points of argument. The first of these is this. Because the fundamental right to possess and carry weapons for self-defense is at the core of the Second Amendment, as affirmed by both this court's rulings and by the historical understanding of the Second Amendment. And secondly, because New York's proper cause law effectively turns what has always been considered a fundamental right into a privilege that is only granted to a few. In the years 2016 and 2017, respectively, Mr. Robert Nash and Mr. Brandon Kosh of Rensselaer County both applied for concealed carry licenses from the appropriate licensing officer in their district. Both of these men already had restricted licenses, which allowed them to carry firearms for hunting and for target shooting, but they wished to have the restrictions on these licenses lifted so that they could conceal carry firearms for the purpose of self-defense. Mr. Nash cited a recent string of robberies in his neighborhood as his reason for applying for a license, while Mr. Kosh cited his extensive experience with the usage of firearms and his desire to exercise his right to self-defense. Both of these men had taken all the necessary training courses to obtain a license, but both had their licenses denied because, according to New York law, in order to get a concealed carry license, one must demonstrate to the satisfaction of a licensing officer that a proper cause exists for the issuance of that license.
Your Honor, self-defense is a fundamental right and has been considered so even before America's founding. Tucker's Blackstone called self-defense the first law of nature. John Locke was
Counsel,
quoted. Yes, Your Honor.
what does the Second Amendment protect?
Your Honor, the Second Amendment protects the right for a citizen to keep and bear arms for self-defense, as this court held in District of Columbia versus Heller. Also in Caetano versus Massachusetts, Caetano had violated Massachusetts law against possessing a stun gun and was carrying it in public. This court held that she had the right to keep and bear a stun gun. This suggests that the court recognizes a right to keep and bear arms in public.
Some add to this, Your Honor, as established in District of Columbia versus Heller, the prefatory clause, a well-regulated militia being necessary for the security of a free state, does not restrict the operative clause. Instead, it gives a reason for why the operative clause is there. In other words, because the militia is necessary to keep Americans safe, the right to keep and bear arms may not be infringed, or in other words, violated or taken away. The Second Amendment does not say that the right to keep and bear arms may not be regulated or that precautions may not be taken, such as gun licensing and background checks. But when a gun regulation law prevents the average citizen from exercising their right to keep and bear arms, this would count as an infringement and is unconstitutional.
All right, thank you, Counsel. Counsel Johnson, you may continue.
Thank you, Your Honor. Your Honor, John Locke was quoted when he said, "The first and strongest desire God planted in men and wrought into the very principles of their nature, that is the foundation of a right to the creatures, for the particular support and use of each individual person himself." This was something Federalists and Anti-Federalists agreed on in the importance of the right to keep and bear arms for self-defense. During the ratification of the Constitution, New York suggested that the right to keep and bear arms be included in the Bill of Rights. In District of Columbia
Counsel,
Yes, Your Honor.
let me interrupt since you brought these things up. What weapons does the term arms include?
Your Honor, the term arms includes any weapon that does not terrify the people, can be used for self-defense, and can be carried on one's person. In the case of Caetano versus Massachusetts, Caetano possessed a weapon that was not in existence at the time when the Constitution was written. This weapon was a stun gun, and it was decided that it also fell under the protection of the Second Amendment.
Okay, and then just a follow-up question. What difference, if any, is there between the verbs keep and bear?
Your Honor, the word keep is defined as have or attain possession of. Bear is defined as carry the weight of or to support. Keep means that an individual possesses the item or items, while bear means that the individual has the item on his or her person and can support it.
And to add to this, Your Honor, as noted in Heller, the definitions of keep and bear have not changed in meaning or implication since they were used in the Second Amendment. For example, in the 1785 edition of Samuel Johnson's dictionary, keep is defined as to retain or to have in custody, and bear is defined as to carry or convey or to support, and gives the example of bearing arms, as in a coat. It may be added that bear goes further to imply the moving from place to place while carrying arms, and not just going about the house while carrying an arm, instead going about one's daily business while carrying an arm.
All right, thank you, counsels. Counsel Johnson, you may continue.
Thank you, Your Honor. Your Honor, District of Columbia versus Heller played a pivotal role in determining the meaning and implications of the Second Amendment. Justice Scalia's majority opinion in this case explains what the right to keep and bear arms entails and why the militia is included in the prefatory clause. Your Honor, Justice Scalia.
Counsel,
Yes, Your
let
Honor.
me interrupt. So what is a militia, and why did the framers refer to it in the Second Amendment?
Your Honor, a militia is defined as a military force that is raised from the civilian population to supplement a regular army in an emergency. I would define it as a group of able-bodied civilians who take up arms to protect themselves and their fellow countrymen from a threat opposing them. The framers included it in the Second Amendment to prevent a standing army, but to make sure that the citizens were armed.
And to add to this, Your Honor, to borrow Thomas Jefferson's exact wording, a militia is every man able to keep and bear arms. In Federalist 29, Alexander Hamilton speaks of the militia and the military as two completely separate entities, saying that the presence of an armed militia does not lessen the need for a military establishment, and even that a militia is the best security against a standing army. In addition, Anti-Federalist Paper 28 says that the militia is composed of yeomanry of the people, and this term yeomanry refers to the average citizen and not to people in a professional military position.
All right, thank you, Counsel Phillips. Counsel Johnson, you may continue.
Thank you, Your Honor. Your Honor, Justice Scalia sought the meaning of the Second Amendment as it was understood during the founding era. In District of Columbia versus Heller, it was concluded in its ruling that the central component of the Second Amendment is the fundamental right of every citizen to possess and carry weapons for self-defense.
So, Counsel, why did the framers include the Second Amendment in the Bill of Rights?
Your Honor, the framers included this in the Bill of Rights to provide the citizens of the United States with the defense necessary to defend themselves against any threat to their personal safety, which also includes a tyrannical government. This right to self-defense was a fundamental right and is also called the first law of nature, which was stated by John Locke in Chapter 13, Section 149 of the two treatises of civil government, where he says it is the fundamental, sacred, and unalterable law of self-preservation for which they entered into society. This shows how important it was not only to the nation, but to the individuals. It is important to note that this right shall not be infringed.
To add to this, Your Honor, the framers did not include the Second Amendment in the Bill of Rights to invent a privilege that they felt like the American people should have. Rather, the Second Amendment codifies what the founding fathers and people like John Locke and Blackstone and others believed to be a pre-existing right.
Okay, so follow-up question. So what are the limits of the Second Amendment's protection?
Excuse me.
Your Honor, go
sorry.
ahead. Counsel Johnson, please.
All righty. Thank you, Counsel. Your Honor, as far as weapons go, inside the realm of the Second Amendment's protection would be a weapon that terrifies the people.
If I may jump in, Your Honor, in addition to weapons that terrify the people as established by Charles Humphrey's Compendium of the Common Law in Force in Kentucky and William Hawkins in his Treatise of the Pleas of the Crown, Heller said that no doubt should be cast on long-standing prohibitions on the possession of firearms by felons and by the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings.
All right, thank you, counsel. Counsel, you may continue.
The two cases, Nunn versus State and State versus Chandler, both upheld this interpretation that was found in Heller of the Second Amendment. And they held that the Constitution protects the right of the people to openly carry weapons for self-defense. This phrase, right of the people, appears more than once in the Constitution. It appears in the First Amendment, where it says that the right of the people peaceably to assemble shall be upheld, and in the Fourth Amendment, where it says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Whenever this phrase, right of the people, is used, it always means the right of every single individual and not
So,
the right
counsel, if I may interrupt, what is strict scrutiny? What is intermediate scrutiny, and what is rational basis review?
Well, Your Honor, these are the three levels of scrutiny or tests that can be applied to determine the constitutionality of a law. Rational basis review is the easiest of these tests to pass. It asks if a law makes sense legally and ensures that it helps to uphold a legitimate state interest. In order to require intermediate scrutiny, which is the next most difficult test to pass, laws regulating rights must both further an important government interest and do so by means substantially related to that interest. And if a law intrudes on a right, it must provide another way to exercise that right. New York bans open carry firearms and makes it extremely difficult to legally carry concealed firearms without proper cause, a special reason that distinguishes a person from their general community. But New York's gun regulation laws do not provide an alternative way for the average citizen to exercise their right to self-defense. They do not, because of this, they do not pass the intermediate scrutiny test, and neither do they pass the strict scrutiny test, which requires the law to further a compelling governmental interest and to be narrowly tailored to achieve that interest. This level of scrutiny applies to laws regulating fundamental rights, such as self-defense, and it is noted that New York's proper cause law neither furthers compelling governmental interest, nor is it narrowly tailored to achieve that interest.
So, counsel, if I could just ask a follow-up question, is there a difference between openly carrying a firearm and concealed carrying a firearm?
Well, Your Honor, the wording of the Second Amendment makes no distinction between concealed arms and unconcealed arms. It was discussed during the oral arguments for Heller that restrictions or bans on one or the other is not necessarily unconstitutional as long as the right of the average person to obtain and carry a weapon for self-defense is still preserved. In this particular case, however, the only kind of handgun license that New York allows at all is for a concealed carry license. So it is the granting of licenses for concealed carry that is being disputed in this case.
All right. Thank you, counsel. Counsel Phillips, you may continue.
New York's proper cause law allows people to exercise their right to self-defense only when they meet a special requirement. As previously referenced, a special need for self-protection distinguishable from that of the general community or of persons engaged in the same profession. Only allowing American citizens to keep and bear arms for self-defense when they meet a special requirement that is outside of their control, as in a requirement other than achievable qualifications like a license or a training course. This
But
effectively
counsel, how should the courts determine if gun control regulation is considered long-standing?
public safety. Oh, pardon me, Your Honor. To determine this in regard to long-standing laws, since the purpose of the Second Amendment is to protect the right to keep and bear arms from laws that violate that right, and since it is a fundamental right that long preexists any of America's other legislations, the court should not give as much weight in this matter to recent legislation, especially that which was established significantly after the 14th Amendment.
Your Honor, the court should not consider it long-standing. The Second Amendment has been present in our Constitution from its first writing. The other processes, such as background checks and carry permits, have been in place for mere decades, which is not long-standing at all, especially when put up against our Constitution and the gun rights that were in place in England as well. This is in line with what Justice Scalia wrote in District of Columbia versus Heller to focus on laws that were from Blackstone to the 19th century.
All right. Thank you, Counsel Johnson. Counsel Phillips, you may continue.
Only allowing American citizens, Your Honor, to have a license to carry arms when they meet a special requirement effectively turns a fundamental right owed to all into a special privilege that is only enjoyed by a select few. Justice Alito said at the end of his concurring opinion for the per curiam decision in Caetano versus Massachusetts that if the fundamental right of self-defense does not protect the petitioner, in this case, who had used a weapon of self-defense outside the home that was not even in existence when the Bill of Rights was written, when this happens, then the safety of all Americans is left to the mercy of state authorities who may be more concerned about disarming the people than about keeping them safe. Justice Alito's remark here brings up another point.
Counsel, if I may interrupt you before you bring up that point, how should the court consider the public safety implications of licenses to carry firearms?
Your Honor, public safety is an important issue, but as Justice Scalia said in his concluding remarks for the majority opinion in Heller, the enshrinement of constitutional rights necessarily takes certain policy choices off the table, and that it is not the role of this court to pronounce the Second Amendment extinct. The Seventh Circuit Court case Moore versus Madigan interpreted this to mean that the fundamental right to bear arms cannot be discarded only for the sake of public safety.
All right, thank you, Counsel. Counsel Phillips, you may continue.
Licensing officers are necessary for reviewing applications and for granting concealed carry licenses. However, because the nature of the licensing system and the proper cause law are the way that they are, whether or not a trained law-abiding individual may be allowed to exercise the right to self-defense is completely dependent on whether or not a licensing officer thinks that they have a good enough reason. A proper cause could be interpreted by the licensing officer to mean a genuine desire to exercise one's right to self-defense. But as seen by the plight of Mr. Nash and Mr. Kosh, and by many others like them who have been denied the right to conceal carry because they were not in an extreme life-threatening circumstance, this is simply not the case most of the time. New York's proper cause law effectively turns a fundamental right promised to all American citizens into a privilege that only a few may have.
Mr. Chief Justice, it is for the fact that New York has made the fundamental and natural right of a citizen to defend him or herself by keeping and bearing arms in and outside the home into a privilege only available to a few under extreme conditions. We pray that this court finds in favor of the petitioners and holds the New York's regulations and denial of these licenses is unconstitutional.